Good morning, everyone. Welcome. I'll wait for my co-presenter, Ljubica, to join us, and we'll give everyone a couple minutes to join in.
Hi, I'm here. Jonathan, I think you have to put my screen back on.
Okay.
There we go. There we are.
I guess I'll allow you to join us this morning.
Thanks.
Good morning. Yes, Ljubica, it's good to see you.
Good to see you too.
I will say before we begin, we are in our office today because, of course, as of January 31st, the Public Officer of Health of Ontario on last Friday, he mentioned that the prohibition to the prohibition to work away from the office, the forced working from home, was stopped. But I haven't seen it yet transferred into the regulations or just yet. But that was the advice that was given, that employees can indeed work from home. But I'll introduce myself first. My name is Jonathan Borrelli. I'm the leader of the Employment Department, Labor and Employment Department here at Kaiser Mason Ball. And this is my colleague, Ljubica Durlovska.
Hi, good morning. Happy Groundhog Day.
That's right. That's right.
It seems like it's been 2 years of Groundhog Day, hasn't it?
That's true. That's true. Well, I heard the groundhogs didn't really agree today anyway, yeah. But we will see. But we're very happy to be here. We're very happy to talk about this very topical topic, the right to disconnect policy. Kind of caught us by surprise. I think it caught a lot of employment lawyers, HR practitioners by surprise. But here we are, and we're really happy to talk about this. There are the question and answer sections. I just have another screen here. My apologies. So feel free to ask questions in the chat. Feel free to ask questions in the questions and answer, and we'd be happy to get to your questions. We'd like, we're not going to wait until the end to answer questions. So when I'm just going to keep my little Q&A section open here. If I see questions, or if I see a question in the Q&A or in the chat, I will get to it, because I think it's important that we make this more of an open discussion as much as we can. So before we get into all of the details, I wanted to just touch upon the newest updates other than the right to disconnect, just as a refresher for all those joining us today. The Working for Workers Act was passed into law in December of 2021. It included the right to disconnect, of course, the prohibition on non-competes on employees, with very specific exceptions. There was the new allowance for any delivery drivers to use the washrooms under the Occupational Health and Safety Act, so it's now a legal requirement. And there were also new rules for temporary help agencies and recruiters, and also for employers who use temporary help agencies. I think it's important for any employer watching this who who uses temporary help agencies. There are certain documentary requirements they have to keep, and now they've been enhanced since all temporary help agencies and recruiters have to be licensed. So that's important to keep in mind. Going a few months back, of course, the COVID period, that special COVID-19 period, was extended until July 31st. Or is it? Ljubica, do you think that special COVID-19 period is going to be extended?
I don't know. So far, I think we've had, how many, 3 or 4 extensions of this COVID period. So I think as long as we are in the grips of some form of COVID and businesses are being impacted, then that COVID period is going to keep being extended out, unfortunately or fortunately, depending on which side you land on. Yeah,
no, definitely. If you were to ask me if I were a betting person, I would say it probably is not going to be extended. But I would be happy to be proven wrong. And we never know what's going to happen in the next 4, 5, 6 months. So of course, we'll keep all of our clients posted. And as I mentioned at the top, on January 31st, just this past Monday, it is permissible to have employees work from the office, although it was encouraged, not just mandatory. Now it's encouraged for employees to work from home. So it's important to keep that in mind. But of course, today we're here to talk about the right to disconnect. We're going to call it RTD. I don't know if that moniker is going to catch on or not. Disconnecting from work.
Right. So before we delve deeper into what it means to disconnect from work, I think it's important to give some context to this law, because it seems like only yesterday the right to work from home was sort of the next big thing, right? If you look back 5 years, even 3 years, that was looked at as sort of the golden ticket to a work-life balance, and employees would strive to have this work from home arrangement with their employers. But now, fast forward, 2 years and a global pandemic later, when work from home seems to be the norm rather than the exceptions, those employees who thought that working from home would help them to achieve balance are actually finding themselves working more, answering emails at 3 a.m. and expected to be available around the clock. So these changes that we see in the Employment Standards Act are really meant to address this sort of burnout of employees and to ensure that there are clear set expectations by employers in order to allow their employees to have a work-life balance, or having that on or at work and not at work, on and off hours, right? So the ESA gives us a very sort of vague definition of what it means to disconnect from work. And it says that disconnecting from work means not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or reviewing of other messages, so as to be free from the performance of work. So if you think that that is very vague, I agree with you, it is. Minister Monty McNaughton commented on this, and they said that it was left deliberately flexible to allow employers to tailor their policies to their specific workplace. But it was reiterated that the need for businesses to understand that when their employees are off the clock, they need to be off the clock. So let's delve deeper and see what it means to be off the clock.
Yeah, and I'll echo what you said. I found it to be pretty broad, the definition of what it means to disconnect from work. And that was intentional, right? But really the context, like you said, Ljubica, is important. The government recognized that there are a lot of employees who are just working more. And it might not be a bad thing for employers. Some employers would say that's great, we're getting more done. But of course, there are other issues that come with that. And the Minister of Labor did mention burnout specifically when he was introducing the first draft of the legislation. And there have been more remote workers, of course, because of COVID, but really that was a trend that happened before COVID. And even places in other places around the world have introduced these types of policies, including before the pandemic. So I think in a grand scale, in the large scale, what we're really getting at is what is the culture of the business, right? And what kind of culture does HR and the ownership and management want to cultivate? And that's really what I think the policy gets at. So I want to just briefly touch upon the boring parts, the legal requirements. This is exactly what we know from the Working for Workers Act. So of course we have a definition, like Ljubica mentioned earlier. I think that definition should go directly into the policy. The other things for any manager or HR professional who is implementing these policies, the number of employees matters, right? So if an operation has less than 25 employees, they are not right now, well, they're not legally required to have a right to disconnect policy. So small businesses aren't required to have the policy, right? And really that's what the law says. The law says an employer must have a policy on right to disconnect. It doesn't say what the policy has to entail or how it's going to be enforced or what's going to happen, but the policy must exist, right? So for any business that has more than 25 employees, and then each year, I think an employer has to review how many employees they have, because if they, are on the cusp of 20 employees, and then they have 25 as of January 1st, they have to have the policy in place. The contents of the policy, under the text of the law, the definition has to be in there. The date that the policy was prepared and updated must be a part of the policy. And, we've included the vague term at the end, such information that as may be prescribed. And that's really the government's way to say, okay, there may be some other requirements, other exceptions. We're going to talk about managers, of course, that are in the policy, but we might include it later in a regulation. They haven't done that yet. We haven't seen any regulations related to the right to disconnect policy. And so we're waiting on that. As soon as we hear anything, of course, we'll let you know. And the last thing, the policy itself, like a copy of the policy, has to be retained for 3 years. However, an employer would retain that. So just before we get to the next part, I just want to address a couple questions that have come in, and feel free to ask questions over the chat and the question and answer. What positions will be impacted by this? So right now, as far as we know, every position is impacted by the right to disconnect policy. But like Ljubica said at the beginning, the minister made it intentionally vague, and it's up to the employer to implement a reasonable right to disconnect policy. We don't know whether managers or supervisors will be exempted or not. We don't know if other certain professions, lawyers, dentists, accountants, veterinarians, etc., construction workers, we don't know if they'll be exempted. Those exemptions haven't been confirmed in the regulations yet. I would expect it to happen relatively soon, definitely before June 1st, when the law, June 2nd, when the policies have to be in place. And also, of course, there's a provincial election coming up, so I'm sure the Ministry of Labor is working fast to make sure the regulations are updated. There's another question about on-call employees. We're gonna discuss on-call employees specifically, but I mean the general answer to that question, Rabia, is it's up to the employer to determine a reasonable policy on how on-call employees are going to be treated. But as we, I think that's an important segue to our next point, which is, okay, these are the legal requirements of the right to disconnect policy, but how does it interact with other laws, specifically the other clauses of the Employment Standards Act? And being an on-call employee is one of them, but Ljubica, how do you see this interact with other clauses of the ESA?
Right, so businesses have to remember that the right to disconnect policy isn't happening in a vacuum. It's not like you can all of a sudden, decide when your employers can work and not work and go outside of the four walls of the Employment Standards Act. So what I am advising our clients is that you have to use the other rules and laws in the Employment Standards Act to sort of to frame your right to work or right to disconnect policy, right? Because it's important to keep these things in mind, and you can't go outside of this. So the first one that is sort of a big one, and one that a lot of lawyers are talking about, is the 3-hour rule. So in existence right now, the Employment Standards Act, or the ESA, you'll hear us refer to it as the ESA, says that where an employee who regularly works more than 3 hours a day is required to present themselves for work but works less than 3 hours despite being available to work, the employer has to pay that employee for at least 3 hours of their regular wages. So normally we see the 3-hour rule apply where or interpreted to mean that presenting yourself is physically presenting yourself at the place of work. But if your new place of business happens to be your home and you're required to answer sort of one email outside of your regular work hours, then employees might be entitled to that 3 hours of pay for having to present themselves at work, but not working for more than 3 hours. So that 3 a.m. email might trigger the 3-hour rule. Again, we don't have any precedents on this. We don't have any sort of clues as to how it will be interpreted. But I mean, if the workplace has gone from the office to the home, then it only makes sense for this interpretation to be in place, right?
Of course, the 3-hour rule, there are exceptions to that 3-hour rule. You know, managers and supervisors, it doesn't apply to them. So we're not saying a manager has to be paid for 3 hours if they answer an email at 11 p.m. But for non-managers or non-supervisors, it might impact. Although I'm going to talk about that in the exemptions part. Sorry, Lisa.
Right. So the other biggies when it comes to on hours, off hours, is the existing limits on hours of work. So currently there's a daily limit of 8 hours and a weekly limit of 48 hours, other than by written agreement between the employer and the employee. There's also a requirement for hours free from work. So on a daily basis, an employee has to have at least 11 consecutive hours off work within that 24-hour period, except for on-call employees, right? So I think employers who already work with on-call employees might already know that, but that's one of the biggies for on-call employees. And between shifts, employees have to have at least 8 hours off of work, except for split shifts, or if they have an agreement to the contrary, or if they have an agreement to work more than 8 hours, or to be off work less, if that makes sense. And then there's a weekly requirement of 24 consecutive hours off per week, or 48 consecutive hours every 2 weeks. So I think that's more talking about a right to a weekend, right? So within those parameters, you have to think about how your workforce is structured. And like Jonathan said, there's a culture within your workforce, right? Some might have the culture of logging on at 9 and logging off at 5. And so your concerns might be different than someone maybe who works across time zones, or who works on call. So you have to have all of these things in the back of your mind when you are thinking about how you're going to structure your policy. Another big one is overtime, because the way that you structure your policy will impact overtime hours. Or to put it another way, you might find yourself paying more overtime because of the strict delineation of on work or at work and off of work. So that if your employee does come in to the office, or not come into the office, but log on to the office and answer an email, answer a call at some time that's not within your right to disconnect period, then they might be entitled to overtime hours or different hours, right?
Actually, Lisa, there was a question about overtime. So I'll ask you now, since you're addressing overtime. Someone's asked, can we assume that pre-approved overtime would be an exception? So I'm assuming pre-approved overtime refers to, I guess a regular standing agreement, written or unwritten, although I would encourage that employer to have a written overtime agreement, make sure that it's very clear if the employee is working more than 8 hours a day or more than 48 hours in a week. Does pre-approved overtime fall under, the policy?
Yeah, so that's a really good question. And I think that goes back into how many of these employees do you have? Is your business structured such that you require overtime? Or is it just that this one employee, perhaps a manager who might be exempt at the end of the day, we don't know yet with the regulations not being out, will it impact them and they'll be exempt from the overtime pay or even the right to disconnect policy? So I'm not sure how it will impact, but you should definitely have it in mind when you're drafting the policy, or at least thinking about how you're going to structure your policy. Because I think at the end of the day, as long as you acknowledge that there are workers within your organization that have to work overtime, then you can make that specific exemption in your policy, right? But again, this is all subject to exemptions in the regulations, which we don't have yet. I hope that answered your question, vague as it was.
Yeah, but I mean, what I would add to that is there needs to be clear written agreements with employees related to regularly scheduled overtime. You know, if you ask an employee, you know, once or twice a year to work overtime, that's fine. But if an employee is regularly working more than 8 hours, and sorry, non-manager is regularly working more than 8 hours a day or more than 48 hours in a week, there should be a written agreement with that employee, period. Right. Yeah. So, and I think the right to disconnect policy should definitely address any, you know, freestanding or, you know, freestanding overtime agreements and any overtime clauses in employment contracts. Right. I think that's reasonable. Yeah.
And that goes again, that's because your right to disconnect policy isn't happening in a vacuum. You have to take into consideration all of the rest of the rules and regulations, and also how your business operates, and put those two together to come up with something that works for your business. Mm-hmm. Right. So I'll send it to you, Jonathan, to talk about the vacation, the leaves of absence and the exemption.
Yeah. You know, breaks and vacation. When Ljubica and I were talking about the presentation, essentially a break and vacation is already, you know, a time when an employee has the right to disconnect. Right? What is vacation? Vacation is when an employee is free from, you know, the performance of their job duties, essentially. Same thing with an approved leave of absence, job protected leave of absence, you know, an accommodated leave of absence, partial or full, right? So I think a good right to disconnect policy is going to address, okay, well, when you're on break, that's also going to be considered a time when you have the right to disconnect. When you're on vacation, you have the right to disconnect. But on top of that, if there are certain employees, you know, probably managers, but it very well easily could not be a manager. When they're on vacation, they may check their email. Does that mean that they're still on vacation, right? If they have a right to disconnect and they're on vacation, how do those interact? So I think it's important the policy address the company's and the employer's expectations while an employee is on a break, while they're on vacation, while they're on a job protected leave of absence under the ESA, or under the Human Rights Code. And it should be made clear, right? And it very much depends on the business. Of course, we're always going to, you know, adhere to the minimum standards of the Employment Standards Act and the Human Rights Code. But how it is implemented in the business is up to each individual employer. So I think it's important for every employer to think about, how do we want to treat vacation going forward? Because it very easily, the right to disconnect policy is going to apply on vacations. And I want to talk about existing exemptions. I mentioned, you know, managers, supervisors. There are plenty of other exemptions under the Employment Standards Act for certain sections not applying to certain workers. There's no blanket, you know, exemption for every single, you know, worker who's governed by a college, let's say. It's very specific. So it's important that all of the existing exemptions are reviewed by the employer, by HR, and build that into the right to disconnect policy. And the last thing I'll say about that is, you know, for employees who are managers, who are supervisors, they have to actually be managers or supervisors. And what that means is they have to do, you know, a majority of their tasks has to be related to managerial or supervisory duties, right? It has to be not just occasionally doing managerial or supervisory duties. In that event, they may not be considered a manager or a supervisor, and those exemptions may not apply to them. And the right to disconnect policy may, in fact, apply to them. we're anticipating that managers and supervisors are exempt from the right to disconnect policy or some other exemptions related to that. We don't know just yet. We haven't seen the regulations. So it's important to keep in mind all of the existing exemptions under the Employment Standards Act. We want to take the rest of the time in our presentation to talk about planning the policy, things that you might want to include. All of the things we've talked about now, those are the minimum standards, right? And no employer can agree with an employee to contract out of them unless the Employment Standards Act allows it. So you can't write a deal with your employee, okay, you're a one-off that, oh, the right to disconnect policy doesn't apply to me just because, right? Unless the Employment Standards Act allows you to do that. So there are, Ljubica and I and our colleague Sarah have brainstormed, some other ways, other things that employers should keep in mind when you're planning the policy. So first, we want to talk about the impact of the completed policy on the workplace and what you might want to anticipate. Some special considerations I want to go into detail with, and some other considerations we may or may not have time to speak about them, but we wanted to draw them to your attention. And then we'll talk about exactly how you want to implement the policy. So when we're dealing with the impact on the workplace, I think it's important that we, here what I want to do is we'll put ourselves in our own shoes after the policy has been created. What are the, road bumps, speed bumps that we want to keep in mind? So Ljubica has identified 3 of them. And I've already kind of addressed the managers and supervisors, but Ljubica, why don't you talk about the reprisal and a potential breach?
Right. So in the planning stages or the conceptual stages of your policy, you should turn your mind to how the policy will affect your workforce and what will happen if there is a breach of the policy. The two biggies and 2 ways that a right to disconnect policy can affect business negatively is reprisal and harassment. So in terms of reprisal, the ESA says that employees are protected from experiencing reprisal by their employers, meaning that employers are prohibited from penalizing or threatening employees for trying to enforce their ESA rights or health and safety rights for that matter. So if you consider what happens if your RTD policy states that employees have a right to disconnect, let's say at 5 p.m., but then you have a situation where an employee is asked to attend a meeting that runs past 5 p.m. Now, it's funny because normally we would expect an employee to stay and continue on with the meeting until it ends. And we normally see these employees as being flexible. But given your RTD policy, does this employee have a right to leave the meeting? Click that leave meeting button right at 5 o'clock, whether it's over or not. And can any action be taken against them for doing that, right? Given your right to disconnect policy, and will any action be seen as a reprisal for trying to follow a policy that you have in place, right? Now, in the same vein, we have to think about what happens when there's an abundance of work, let's say, and a manager asks their employee to log in past the disconnect period, for example. Yes, it might be a breach of the RTD policy, but can that amount to harassment if it is happening often? Can an employee claim that they're being harassed because they're being asked to breach this policy? And by that token, will employees have an easier time claiming constructive dismissal because of the employers or supervisor breaching this RTD policy or bending the policy as they see fit based on their amount of work or based on how they're required to connect? So when we think about breaches, we have to think about breaches by the employee as well. Now, I, for one, know that I tend to log on at all sorts of hours to do my work, and it'll take employees some time to adjust to RTD policy, right? And as with all other policies, employers have to think about and clearly set out what the consequences to the employee are going to be. So will it be a verbal warning? Will it be a written warning? Does it depend on which part of the policy they have breached? Can a breach ever be result in an outright termination of the employee? We don't know this. We don't know how this is going to shake out. But I will say that I think just because you have a policy, it doesn't mean that you have an automatic right to discipline or terminate. So you have to be careful with this policy as with any other, because all breaches have to be taken on a case-by-case basis, as with all other misconduct and behavior issues, right? Because termination of an employee is often called the capital punishment of employees, and as such, it has to be treated very delicately, right? And there are many, many examples in our case law of employers being sued for wrongful termination or constructive dismissal for disciplining in the wrong way. Now, we don't have any case law here, but we can draw on other jurisdictions that have had this law already. And we've seen some courts say exactly what I just said, which is that one single breach of an RTD policy is not necessarily enough to terminate the employment of an employee, even if that instance was a serious one, right?
Well, I want to really just nail down what we're talking about as a breach. If you have an employee, and let's say there's a section in your policy that says, if there is an emergency, and I'm going to deal with that, if there's some sort of urgent event, if the factory is on fire and you have, a manager, and I see questions just come in about that. Yeah, so that's something I want to address, where there might be situations where an employer has the ability to contact an employee, even if they are exercising their right to disconnect, and say, there's a fire, there's some sort of emergency, there's a provincial state of emergency, there is a flood. I mean, it's supposed to rain a lot today and then snow later. And the employee says, no, I'm choosing to exercise my right to disconnect, and I'm choosing not to connect to work, right? The policy is mandatory. What's included in the policy is up to the employer. So that policy might say, well, if there's an urgent situation and an employer requires that employee to work, the employee has to work. So if the employee says, no, deal with it yourself, that might be considered a breach under the policy. And as Ljubica said, in other jurisdictions, it wasn't taken as cause, right? So we can discipline for that, but it might or might not be enough to terminate an employee for a cause. But definitely, I think a good right to disconnect policy is going to have, some very limited circumstances where the employer can, still contact the worker through reasonable means if there is an emergency situation. Yeah, and that depends on the nature of the business. It could be a 24-hour factory. It could relate to where people live, which is a 24-hour operation, and that's going to be addressed in in each unique policy.
Yeah, and if you want some specific wording, we have some guidance from other jurisdictions. So in Belgium, their specific, pardon me, their specific exemption clause says that in the event of exceptional and unforeseen circumstances requiring action that cannot wait until the next working period. So that's some specific language you can include there, and also broad enough to include those sort of emergency situations that Jonathan was talking about.
So definitely, and that's what we're talking about, a breach by the employee. Right. And let's be clear, an employee has a right to disconnect. If an employee chooses to connect to work, that's fine. Right. An employee can work if they want to work. But if they're choosing to exercise the right to disconnect, and then they're required, to work by the employer, that might be considered a breach. And that should be, defined in the agreement. Or in an employment agreement, sure, but in the policy.
Do you think that an employer can or should take steps to ensure that employees are disconnected at the time when they're supposed to be disconnected. So, turning off email functions or other functions in whatever technology they're using. What do you think, Jonathan?
Yeah, I think that's extreme, right? So what are we talking about there? If an employee says, I am on vacation for a week, and we want to make sure we don't pay that employee extra pay while they're on vacation, and we want to make sure the employee says they're disconnected and they are truly disconnected. Does that mean you can change their email password so they cannot even log into their email to make sure they are disconnected? I mean, the email is a property of the employer. It's possible. I think that's extreme, right? Again, it's a right to disconnect. It doesn't mean that every employee must disconnect after, the end of the core hours of the business as defined in the policy. So, but I could come up with probably some an extreme fact scenario. Maybe in a few years we'll see that case come through in the courts, but it would be extreme if an employer wants to do that. I don't think it's completely unheard of, but it would be extreme. Yeah.
I think also, pardon me. I think also that as these laws come out, I think technology is also going to adapt to allow us to have more time off, so to speak. So that could be in the form of an employer being able to click a button and disconnect an employee, or in the form of, something to the, in the same vein as the out of office response that says that I am currently disconnected from work. Here's our working hours. Please get in touch with me then, or I'll respond to you then, right? So I think that technology is going to play a big part in how we do this. But again, with it, we have yet to see it. Now, I wanted to touch on, because when we talk about breaches, we have to think about who is enforcing the policy and how that's going to shake out. So normally in a bigger operation, 25 plus employees, the managers and supervisors are those people who are overseeing the workforce. And because employers are vicariously liable for the managers and supervisors, you have to make sure that those managers and supervisors are perhaps a part of the planning stage, but also I would recommend them being a part of the entire process, including training on the policy after the policy is written, so that you can make sure that those supervisors and managers are on board, that they're enforcing properly, that you're not going to see breaches of this policy, whereas before they might have been able to send that text message at 9 p.m. regarding an important but not urgent matter. They might not be able to do that now, and you need them to know that, right? Now, as we said many times before, managers and supervisors might themselves end up being exempt from the RTD policy, but that doesn't mean that you shouldn't get buy-in from them and get them on board in order to structure the policy and make sure that it's enforced appropriately. Right?
Yeah, no, that's a really good point.
Yeah.
Yeah, I want to talk about, so that's kind of, putting ourselves in our own shoes after the fact, after the policy's been implemented, and what can we, keep in mind? What can we include now in the policy for later? I want to talk about some other kind of special considerations while we're planning the policy. So there are these 4 things. Some of them we've touched upon already. The number of employees. So as I said, if there is, I can just come up with a fact scenario, like an American company, they have only a small office in Ontario, 10 or 15 employees, maybe they're growing, and that's great. How many employees are they considered to have if they're, let's say an international company? Or if they have other employees, but they're not included in Ontario, right? And I think this is important to discuss because there was a case that was determined by the Superior Court in Ontario that talked about severance pay paying employers, and what payroll do we look at when we're trying to consider who is a severance paying employer or not. The law says right now is the court is going to look at the most broadest interpretation of that employer's payroll. And it is going to include a global payroll, not just an Ontario payroll, not just a Canada payroll. It's going to look at the entire company, right? And it was more of a shift. This was last year. The case came out. It was definitely a shift from how the Employment Standards Act and their officers and the Ontario Labor Relations Board was implementing that. So I think something to keep in mind for employers who have multiple offices, not just in Ontario, if they have parent companies that are outside of Ontario, outside of Canada, the number of employees matters, and it should really be considered. How many employees really does the company have, and it may very well include every worker in the world. So if it's only a small office in Ontario, but there's 500 employees in the US, that may force the employer to have a right to disconnect policy. There are a couple questions coming in, and I want to address them as they're coming in because I think they're apropos. So there's a question here, and Ljubica, we can both take this one, and then I'll get back to employee travel. Can employers send emails after work hours, but without an expectation from an employee to answer the next, without an expectation from an employee to answer that day, or they can answer the next working day? I would say the answer is yes, right? I think that should be made clear in the policy. So if an employee is choosing to exercise the right to disconnect, right? Not every employee has to. If an employee says, listen, when I'm, after I leave work or after the core hours of business, if I'm not working, I'm not going to reply to emails, right? And that could be made very clear, one-on-one with HR and that employee. But if an employee has chosen not to exercise their right to disconnect, the employer can send an email, they can respond to an email. But if that employee chooses to disconnect, perhaps, they don't check their email after a certain time, or they don't get notifications that they're getting an email after a certain time. Like Ljubica said, you engage technology to do that. But, I think a policy can be made very clear that an employer might send you an email. Your manager might send an email, or a client or a customer, but you're not required to reply to it if you're exercising your right to disconnect.
Unless urgent, right?
Sorry?
And unless it's urgent.
Oh, well, if it's an urgent situation,
matter, right? And I
totally
think that's where that little flag on your email, the urgent, will make a difference, right?
Mm-hmm.
Or perhaps you have different methods of contacting each other if it's urgent versus not urgent.
Mm-hmm.
But that's something that really depends on your work culture, how you do business.
That's right. Another question in terms of core business hours, and this is something that I'll be speaking about as well, but we can address it now. Do you think it's a reasonable place for employers to start in terms of the disconnecting period? And really, I would say there's no one set answer to that question, right? And again, this is why the law was made so broad, right? The law requires the employer to have a policy on right to disconnect, just like vaccination, right? It's almost identical. The government has never said what is to be included in the vaccination policy or the right to disconnect policy, but it's the law that you have a policy. So I think, yeah, it's a very good place to start in terms of what are the core hours of business? What are the times that every employee or certain types of employees must be ready to work, be ready, willing and able, and like available to work. If they're at work, sure. If they're remote, what does it mean for an employee to be remotely available to work? No, I think that's a great place to start. Ljubica, what do you think?
Yeah, I agree with you 100%. I think a good starting place, and I think we were going to talk about that, but we can take that question on here. A good starting place is to analyze what your business looks like. What is the culture of your business? What kinds of employees do you have? So workplace can consist of work from home employees who have to turn up at an office. It can include, salespeople who have to either work from home and see customers or clients. It could include, people who work from home solely, but also have to interact with others. And it can include people who have to interact with others across time zones too. So when you are figuring out whether or not you even can have core business hours, you need to see what types of workers you have and to what extent you can limit core hours. And that's a fine starting place. That's a really good starting place, because then that will delineate the at work and off of work to an extent, right?
There's another question, speaking about managers. What would be our thoughts around supervisors sending, actually, it's a similar question. Supervisors sending non-urgent emails after hours, but clarifying that no action is needed until the next day. Yeah, I think that's the same question that was asked before. I think that's fine. And I think a good policy is going to explain if an employee is exercising their right to disconnect, they're not required to answer. But I think supervisors can still send those emails. And again, I think the bigger question is, what is your workplace culture, right? Is the workplace culture that certain employees are in fact required to get back to clients within 4 hours? If that's the case, if it's very clearly written in an employment contract, right? And I think that's key, then those expectations are going to be made very clear. If, by virtue of this policy, certain job duties are going to change and certain expectations are going to change or be relaxed, let's say, I think it's a really good time to review job descriptions and review terms of employment contracts. I want to touch upon these 3 points, and we have a couple more slides I want to get through. And of course, I'm always happy to talk about these matters offline as well. Employee travel. Does employee travel count as connected to work, disconnected to work? I think any good policy is going to define that and address that, especially, like you said, Ljubica, sales employees. If an employee is traveling, they have to travel a long distance. Is that considered working time? If they're on a flight for 6 hours, is that considered disconnected, connected? I think that's an important part of any policy that should be addressed. On-call workers, I think, is probably the most important sector of workers that this right to disconnect impacts, right? So I think any employer who has on-call workers, now is the time, now until the beginning of June, is the time to really think about, how the business uses on-call workers and how they want to go forward using those on-call workers. So I think it's fine to have those on-call workers. But if an employee is waiting for work, are they connected or are they disconnected to work? If they are connected, is there an obligation to pay them, right? If they're, how do you notify if an employee is on call, off call? The limits on hours of work, having enough time in between shifts. That is an important, important section of any policy. And I really want to stress, it's up to every individual employer to put in, reasonable terms that works for their business, right? Of course, in compliance with the Employment Standards Act. So for any on-call workers, I think they're definitely, or if an employer has on-call workers, it should really be addressed in the policy. It's going to be specific for each employer. So we're always happy to talk about, the nuances of how on-call workers are treated under the policy. So I know that it's garnering a lot of attention. And, I've already talked about exceptions in the policy. What are some types of exceptions that I could see in the policy? I mentioned a few of them, like a provincial state of emergency, weather events like we had a couple of weeks ago, fire, natural disasters, crime, something that's outside of the control of the employer. And this is a definition that I read somewhere, something outside of the control of the employer, which left untreated could result in serious consequences. Okay. But I think if there's any exceptions, they should be used exceptionally, right? If an employer is, using an exception once a week, I think that's too much. And I think, the policy has to be reviewed. I think sick calls, when an employee calls in sick and you have another employee who has said, I have disconnected from work. they should make it very clear. The policy should be made clear, and that employee should make their intentions clear. If there is a sick call, I don't want to be asked if I'm disconnected from work. Or perhaps it could be part of a reasonable policy. If an employee is called in sick or they cannot come to work for, without a lot of notice, we might reach out to you via email, via phone, via text message, and that is not a breach of, or that's not considered reconnecting you back to work, right? That can very easily be added into a policy, as long as it's reasonable. And lastly, I think if there are operational requirements, I mentioned before, if it's a 24-hour operation, if it's related to, healthcare, people where places live, if there's night shifts, things like that, there can be, certain exceptions for operational requirements of the business, and that should be made clear in the policy as well. What I want to talk about now, these are things that, Ljubica and I, we had brainstormed, and I should say Sarah as well, our other associate. Other considerations, we don't really have time today to talk about all these other considerations and what may be included in your policy. But I'll highlight some of them. The impact of time zones. My sister-in-law started a new job, and her team is all located in Western Canada. But she, is she required to work from 9 to 5 plus an extra 2 hours? So are her core hours of work 9 to 7? Is it 11 to 7? I think the impact of time zones. Social gatherings and team building. I think they can be separated, but if an event is required by the employer, is that employee required to attend, and do they have to be paid for it? I think there's a difference between social gatherings and team building. Team building is probably more on the side of training, but that, you might want to address that in a policy. Conferences tend to be a long period of time, and that if you have employees who attend a lot of conferences, should be addressed. Ljubica and I, we talked about waivers, and can an employee sign something to say, okay, now I'm opting in, now I'm opting out? I don't know how much I don't know how reasonable that would be, but I think it's yet to be seen. We got some questions before about how do we know when a day starts, or what are the core hours? And if you answer one email in the middle of a rest period, the 11 hours or the 8 hours in between, does that restart the clock? Right? I think these questions are going to be asked, and it might be good to address them in any policies. In France, they have, I believe it's the law, or it's about to be passed, where employees have a right to request remote work as a part of the
reprisal, right?
Yeah, exactly. So we don't really have that here. I mean, elements of that are included in accommodation law and human rights law. And we talked about consequences for breach. If there are any consequences for the employer, for the employee, it really should be addressed in the policy. So these are all things that you may want to consider including in the policy. But in terms of drafting the policy, and now that you've considered everything that you do and do not want to include, Ljubica, where would an employer start?
So I think we kind of covered most of these as we went along, but I think just to remind you from the beginning, there are very few things that are currently required. One is the definition of the right to disconnect. The second is the date the policy was prepared or updated. And unfortunately, that's where the guidance stops. But we will wait for further guidance via regulations to see. But while we wait, I think you can use this grace period until June 2nd to gather the information on the office culture and how the right to disconnect policy could operate in your business. So like we talked about earlier, you want to think about how you connect with your workers and what it means to be at work or on or off of work, right? And what kind of population is your workforce consist of? So for example, do you have a lot of young workers with young children? I know for myself, I'm probably the most productive in the evening after the kids go to bed. And Jonathan will attest, we tried to have a Zoom meeting just the other day when my kids just came home, and they were, things were devolving very quickly. I couldn't work. Jonathan couldn't concentrate because of them. So
well, they were too cute. How could
I had to disconnect and reconnect after they went to bed. So you have to have these sort of conversations with your workers. You have to know where they're coming from. And I mean, that ties into accommodation as well. If a worker says, well, I physically, I cannot log in at a certain time because I have, I have an obligation to take care of, a disabled family member or children, or maybe I'm disabled myself, so I can only sit for 2 hours, or you have to take those things into consideration, and they need to be addressed in the RTD policy as well, right? And to that extent, to the extent of getting buy-in, you need to talk to your employees to see what they need, right? So Jonathan and I had discussed what's the best way for a business to do this. And we thought, your 25 plus employee workplace already has or should have a joint health and safety committee in place that consists of both managers and regular workers, right? So that you can recruit that group of people that are already formed to help you to decide what should be in your RTD policy. And so, like I said, you'll get more buy-in by doing that, because when people have a say in a policy, they are more likely to follow that policy, and that's been proven time and again. And we already talked about the identifying affected job categories. So if you are in a workplace where there are different categories that we talked about, then you want to consider each one separately and how the right to disconnect will affect each category of worker.
Mm-hmm.
I think we are 1 minute out.
Yeah,
so I'll let Jonathan sort of do a last little bit here.
Yeah, I'll just talk about implementing the policy. We've talked about managers, supervisors. I think it's important to train them, right? They should know the signs of burnout. They should understand what the definition of constructive dismissal is, so that they aren't inadvertently terminating members of their team. And they should also understand what reprisal is. They should be able to identify it. They should stop themselves if they're about to engage in reprisal. I think it's important to just understand the timing to receive the policy. It's 30 days. If they're a new employee, 30 days. The first 30 days, if they're an existing employee, 30 days from when they roll it out, from the employer rolls it out. And it's important they get a copy of it. Electronic is fine. And lastly, in terms of updating employment agreements, I think it's a good time to review termination clauses, review job descriptions for anyone who you might identify as, they might, have more to say about the right to disconnect. It's a good time to update that. And of course, we're always there to help. I think it's also important, it's a good time just in terms of employment agreements generally. Understand who is a manager and who is a supervisor. Understand who is paid overtime, who is not paid overtime. There are plenty of employees after, they resign, they say, oh, by the way, I wasn't a manager that whole time. So I want all this extra overtime pay because I went to, one conference every month, but I wasn't actually a manager. So I want to be paid for that time. And just generally clarifying expectations of the role, right? That can be done in an updated employment agreement, new job description. And I think that's what's prompting this, right to disconnect policy prompting employers to review all of their policy. So now is a great time to dust off your policy manual, you get a new right to disconnect policy in there, call us if you need any help, review your harassment policy, document that you reviewed it, make sure you have a right to refuse work policy, make sure all your posters are included in there. What else am I missing, Louisa?
I think you covered it.
Yeah. So of course we are, I see there's other questions here. Robbie, I'll get back to you after the call or after our webinar, but we're very happy to answer any other questions that you have. I will just post our emails and phone numbers there if you'd like to reach out to us. And we're very happy for you for joining us. This has been recorded and we're going to post it on our website, kmblaw.com, and we'll make sure we post it on my LinkedIn as well so that everyone can have it. If you'd like copies of the slides as well, we'll send those to all of the attendees. If you'd like them, just make sure you send us an email. We'll make sure you get them. So on behalf of Ljubica and I, thank you very much for attending today. And we hope you have fun drafting your right to disconnect policies.
Take care.
Okay, have a great day, everyone. Bye-bye.